So these are going to be the abbreviations that are used: AG, Attorney General; JD, Judicial District; CBOR, Consumer Bill of Rights. 202.12-A, Residential Foreclosures Settlement Conference. A, applicability. Residential foreclosures involving a home... this is applicable to residential foreclosures involving a home loan on a 1 to 4 family dwelling or condominium in which the defendant is a resident of the subject property. B, specialized RJI. At the time of filing the affidavit of service, plaintiff shall file a specialized RJI on a form by the fucking chief administrator, which shall include defendant's name, address, phone number, if available, email address, the name of the mortgage servicer, a request for a settlement conference. Upon the filing of the RJI, court shall send either the RJI or defendant's name, address, and if available, phone number to a housing counseling agency or agencies funded by New York State Office of AG's Homeowner Protection Program for the JD in which defendant resides, for the purpose of the agency informing defendant about free foreclosure prevention services and available options. In counties, as the fucking chief administrator shall direct, when the plaintiff fails to file an affidavit of service within 120 days, the county clerk shall provide the fucking chief administrator with the case name, index number, property address, and contact info of parties and attorneys. The administrator may take such further action as he deems fit with respect to such case or cases, including but not limited to placing a case on a delinquency calendar, providing case info to a housing counseling agency, or ordering a status conference. C, court shall promptly send to the parties a notice scheduling conference to be held within 60 days after the RJI is filed. The notice shall be mailed to all parties or the lawyers and shall include the mailing address of the property. Notice shall set forth the purpose of the conference, the requirements of CPLR 3408, and what info and papers to bring. The notice shall inform defendant that he must contact the court at least 7 days prior to the scheduled conference by telephone to notify the court if he will be able to attend the scheduled conference. So the rules in here, we have a 7-day rule, a 60-day rule, 1 to 4 family dwellings. The conference shall be held to conduct settlement discussions pertaining to the relative rights and obligations of the parties under the mortgage loan documents, including determining whether the parties could mutually agree to a resolution to help the defendant losing his or her home, and evaluating the potential for a resolution, modifying payment schedules or amounts. Workout options can be agreed to, including but not limited to loan modifications, short sales, and deeds in lieu of foreclosure, and any other loss mitigation options. Court can use a conference for whatever else it deems appropriate, and wherever appropriate, the court may allow the parties to appear telephonically or by video conference, and any representative appearing in the conference shall be fully authorized to dispose of the case as required by CPLR 3408 sub C. If the parties appear by counsel, such counsel must be fully authorized to dispose of the case. If the defendant appears at the conference without a counsel, the court shall treat the defendant as having made a motion to proceed as a poor person pursuant to 1101 and determine whether permission to so appear shall be granted. If the court appoints defendant counsel pursuant to 1102, it shall adjourn the conference to a date certain for appearance of counsel and settlement discussions, and shall otherwise proceed with the conference. If the parties appear by counsel, such counsel must be fully authorized to dispose of the case. If the defendant appears at the conference without a counsel, the court shall treat the defendant as having made a motion to proceed as a poor person pursuant to 1101 and determine whether permission to so appear shall be granted. If the court appoints defendant counsel pursuant to 1102, it shall adjourn the conference to a date certain for appearance of counsel and settlement discussions, and shall otherwise proceed with the conference. So just a date certain, no time rule in that part. The court shall adjourn for a date certain. The parties shall engage in settlement discussions in good faith to reach a mutually agreeable resolution, including a loan modification if possible, consistent with CPLR 3408F. Court shall ensure that each party fulfills its obligation to negotiate in good faith and shall see that conferences not be unduly delayed or subject to willful, dilatory tactics so that the rights of both parties may be adjudicated in a timely manner. The court shall ensure that procedures are in place to enforce the duty to negotiate in good faith as defined in the mandates of CPLR 3408 F, I, J, and K. Okay, so just quickly to go over what those rules that they're talking about are. So this is part of how they decide if they're negotiating in good faith or not. Conduct consistent with efforts to reach an agreeable resolution, including but not limited to avoiding unreasonable delay, appearing at settlement conference with authority to fully dispose a case, avoiding prosecution of foreclosure proceedings while loss mitigation applications are pending, and providing accurate information to court and parties. Neither of the parties' failure to make the offer or accept the offer by itself is sufficient to establish a failure to negotiate in good faith. G. Plaintiff must file a notice of discontinuance and vacatur of the lis pendens within 90 days after any settlement agreement or loan modification within 90 days after the loan modification or settlement agreement is fully executed. H. A party to a foreclosure action may not charge, impose, or otherwise require payment for any cost, including but not limited to attorney's fees for appearance or participation in the settlement conference. I. Court may determine whether party fails to comply with duty to negotiate pursuant to sub F and order remedies pursuant to J and K on motion of any party or sua sponte on notice to the parties in accordance with procedures as may be established by the court or OCA. A referee, JHO, or other staff designated by court to oversee settlement conference process may hear and report findings of facts and conclusions of law and may make reports and recommendations for relief to court concerning any party's failure to negotiate in good faith pursuant to sub F of this section. Upon a finding by the court if the plaintiff failed to negotiate in good faith pursuant to sub F, the court may order remedies, and the court shall, at a minimum, toll the accumulation and collection of interest, costs, and fees during any undue delay caused by the plaintiff, and where appropriate, the court may also impose one or more of the following. 1. Compel production of any documents requested by the court or the court's designee during the settlement conference. 2. Impose a civil penalty payable to state that is sufficient to deter repetition of the conduct but not exceeding $25,000. 3. May award actual damages, fees, including attorney fees and expenses to defendant as a result of plaintiff's failure to negotiate in good faith. 4. Award any other relief the court deems just and proper. Upon a finding that the defendant is the one who failed to negotiate in good faith, the court at a minimum shall remove the case from the conference calendar. The court must consider factors including whether the defendant was represented by counsel in making this decision. L. At first settlement conference, if defendant has not filed an answer yet or made a pre-answer motion to dismiss, the court shall 1. Advise defendant of requirement to answer. 2. Explain what is required to answer a complaint in court. 3. Advise that if an answer is not interposed, the foreclosure action will proceed and the right to assert defenses may be lost. 4. Provide information about available resources for foreclosure prevention assistance. The defendant shall also get a copy of the Consumer Bill of Rights by the court. Okay, this is M. A defendant who appears at the settlement conference but has not filed his answer timely shall be presumed to have excusable default for failing to answer the complaint, and shall be given an additional 30 days after the settlement conference to file and serve an answer without any substantive defenses deemed to have been waived within 30 days of initial appearance at the settlement conference. The default shall be deemed vacated upon service and filing of an answer. N. Any motion submitted by plaintiff or defendant shall be held in abeyance while the settlement conference process is ongoing, except for motions concerning compliance with this rule and its implementing rules. All right, so I just found a discrepancy. So in the CPLR Rule 3408, the notice that has to be sent to the defendant by the court when the specialized RJI is filed, the rule says that it's on a form by the fucking chief administrator. But the actual CPLR says that it's on a form by OCA or in the discretion of OCA by the administrative judge or something. But I definitely can't ask that question because it would be challengeable because, yeah, one says chief administrator, but whatever. It's a fucking form that someone's going to make a form. Plaintiff and defendant shall bring all documents as required by the JHO or judge, whoever's doing the conferences. At the first conference, the court shall determine if the defendant has answered the complaint, and if he hasn't, then the court shall provide him with the information about, the rules about answering. The court shall ensure that procedures are in place to note the vacatur of any defaults upon service and filing of answers pursuant to CPLR 3408 sub M. The court shall schedule such other conferences as may be necessary to help resolve the action. It says shall. The court shall schedule such other conferences. Chief administrator shall establish rules for the training and education of all judges and non-judicial personnel assigned to conduct foreclosure conferences pursuant to this section. There has to be training for judges and non-judicial personnel that are conducting the conferences. The chief administrator shall submit a report no later than November 1st of each year to the governor and to the legislative leaders set forth in Section 10-A2 of Chapter 507 of the laws of 2009 on the adequacy and effectiveness of the settlement conferences, which shall include the number of adjournments, defaults, discontinuances, dismissals, conferences held, and the number of defendants appearing with and without a lawyer. The fucking chief administrator may continue to require counsel to file affidavits or affirmations confirming the scope of inquiry and the accuracy of papers filed in residential mortgage foreclosure actions, addressing both owner-occupied and notwithstanding that they really aren't talking about non-owner-occupied properties, they still want non-owner-occupied foreclosures in this report. That is the end of Rule 202.12 and CPLR 3408.